Good evening. Welcome to this evening's webinar, Navigating the Legal Side of Retirement for Succession and Estate Planning with regard to business. My name is Jackie Broman. I am Special Counsel for Wills and Estates at SPG Lawyers. Now, where there's a will, there's usually an unhappy relative. We don't want problems. That's why we want to do good estate planning, and that's what I am all about. I do deal with the problems if they arise, but I'd prefer to do good work up front. Like medicine, we want to prevention is better than the cure. So I know the light's a little bit funny on my here where I am today, but hopefully you can see my slides well. But there's a nice image of me that's, not all faded and funny. And on the other side of the screen, you'll see that blue and black figure 8. So for those of you who don't have to deal with lawyers very often, you may not be aware that there is an extra level of accreditation that lawyers can get, which then they're a specialist. So again, using a bit of a medical analogy, you've got GPs, which are your lawyers who have a basic law degree and they practice in a few areas of the law. And quite often they're really good, of course. But if you want to be an accredited specialist, you have to go through a big accreditation process with your state body. Now, I went through that in Victoria in 2016. So I have been accredited for 9 years now. So I am a specialist in wills and estates specifically. I did extra study. I did that accreditation program. So if you are ever looking for a specialist lawyer in any particular field, look for that logo. Now, what can go wrong? We want to prevent these things. So from a will and succession perspective, there's 2 ways that people can challenge a will. Firstly, that it is not valid, either from lack of capacity or from undue influence. Or secondly, failure to provide adequately for someone. So those are the 2 ways to claim against a will. However, when you're dealing with business, it opens things up to even more litigation potentially. Because if the wrong people get control of the business, that control often doesn't pass through your will. So control of the business, control of the assets, which might not be in the same entity, can cause trouble. Control ultimately of who has the trust then controls who distributes what. Maintaining value can also be a huge issue, because if something does happen to you as an emergency situation, who keeps the business going to actually maintain value? Because if it collapses, it's probably only worth its plant and equipment. And then authority. Who has authority to keep it going in the meantime? If it's an emergency and you don't actually pass away and you're in hospital for 6 weeks, how does things keep going? So contingency plans, that's what I'm quite often dealing with. And well, why does it matter? Well, I was in business as well, like most of you probably are on this webinar tonight. And we go into business for a reason, don't we? We go in to serve well, to grow an asset, to do well financially, to do what we want to do well in the way we want to do it, and hopefully to build something that is worth something to transfer as a legacy. So of course it matters that you don't want everything to be lost as soon as something happens to you. We don't want to leave our loved ones with the cost, financial burden, the waste of time, the mental health issues of potential litigation, or just the stress of leaving a mess. If we're not thinking about emergency situation, we need to think about our goals for retirement and smooth succession, not an emergency situation. A lot of people bandy around in business that we have to think about the exit at the beginning. So even if we don't have a firm plan, we hopefully have maybe 2 or 3 ideas about how we could exit. And of course, if your business is your legacy and you do want to leave it for your family, we have to make sure that that's going to work. estate planning in 2025 is very different from what it might have been in 1985 if I was doing this webinar back then. It's not just a will anymore. We've got to look at how property is owned. A lot of us now have family trusts, companies, self-managed super funds. Is it owned personally, jointly? All sorts of different ways of owning property. Tax laws have changed significantly, of course, as well. Superannuation is a major asset for most people. It's legislated differently, not necessarily covered by your will. Powers of attorney are much more relevant now. We tend to live longer and have less likely to die suddenly and have either longer periods of being unwell or dependent. Of course, dealing with trusts that own assets aren't assets that are dealt with in the will either, so we need to make sure control passes correctly. For those of you who still have children under 18, guardianship is one of the most important reasons to do your will as well. Who's going to look after your kids? How are they going to raise them? Doesn't necessarily have to be family if your family doesn't have the same values as you. But could be, of course. Appointing a godparent is not a legal appointment, so you do need a guardian in your will. Aged care, we've got new reforms coming in Australia-wide in July, and they're now saying aged care is more expensive than raising a child. We are not planning for aged care very well. How do we do that? And digital assets are something that have only sort of arisen in the last 20 years. Some of us have significant intellectual property. If your business is a creative business or you have a whole lot of things that are stored in cloud environments or other sort of practice management tools. Where are your assets? How do you get them out of this software? Who has control or the authority to use your accounts to recover things? All those sorts of things to think about. And of course, if we pass away without a will, the laws in Queensland are actually fairly appalling about what happens if there is no will. If you have a spouse and no children, it all goes to your spouse, so that's fine. But if you have a spouse and children, your spouse only gets the first 150,000 and then has to divide the rest up between themselves and the kids. 150,000 is not great at all. No spouse, no children, it goes to your parents. For young people, think of young people in mind, no spouse, no children. They might not like both of their parents. They might have been raised in blended families. They might not speak to one of their parents. It's just maybe another reason to speak to young people. But there are a lot of stages before it ends up going to the government. But just to highlight that it's not an ideal situation. But what are we doing tonight? We're talking more about business. So we're talking about how to develop a succession plan in your business. We're talking about how to protect your assets and estate, primarily from a contingent perspective. From an emergency, because I like these documents done in case of an emergency for the next 5-year period, and then your succession plan can be a longer period. We want to minimize tax burden as much as possible on the people inheriting. We want to ensure our structure is right, that our business structure is ready for succession. As your business grows, potentially your structure has to change, particularly if you started out as a sole trader or a partnership. You might have then moved to a company, then you might have added a trust underneath, then your super fund might have bought a building, then you might have had another company, which is a service company for your business. So your structure keeps evolving over time. And I often talk to accountants about what the objective is of a client, because if a client comes to me and they want to deal with succession, I have to see in what list of priorities succession actually is. Because if growing wealth and minimizing tax is still the major priority, then succession has to be the third or fourth priority. It's not a top priority. But as we age and things change over time, succession can then become more of a priority. And of course, then having the right people in the right roles is really one of the keys, because we want control to go to the right people. We want people we trust who will actually do the things they need to do. We want to keep our business running. We need someone who can actually do that as well. So let's get into it. For those who weren't here at the very beginning, I'm recording now. There is no chat function in this webinar format in Zoom. You have to use the Q&A function. So find that if you have a question. I will come to questions at the end. I'll stop the recording so people watching the recording won't get to ask questions, but those lucky people here tonight can. All right. So, in terms of doing your succession plan for a business, I generally think there's 5 steps to doing it. And it doesn't have to be done with a lawyer. You're going to come to a lawyer for specific parts. You're going to probably work with your accountant more than a lawyer, maybe a financial planner in there as well, maybe an insurance broker. Yes, I can make these slides available as a PDF afterwards, and you'll get the recording as well. So, 5 steps to your business succession. You're going to do a fact find. So, a lot of business owners are right on top of all the aspects of business, but some business owners are fully down in the business doing the day-to-day stuff and only come up for a breath every now and then to fully understand the big picture of their business. So fact finding is an important thing to do. You need to know how your business is structured. You need to know where your company constitutions are, your trust deeds. You need to have your primary terms and conditions. You need to know where your employment agreements are. You need to know where your partnership agreements are. All these things that you may have, and then any service agreements for ongoing things in your business, like maybe software or leasing of equipment or leases of premises. Who owns, if you own a building, how is it owned? Where is it owned? What entity? So really having a good understanding of the business structure, the ownership, and all the underlying hows about those things. And of course, your accountant's going to know a lot of that stuff or have a lot of that source material as well. And then identifying the immediate issues. So where's the holes? And again, working with your accountant and someone like myself could identify some of the immediate issues. As I talked about initially, and we'll talk about more, contingent planning is absolutely some immediate issues, because if you haven't got a way of keeping the business running, if you had a car accident and had to have rehab for 3 months, then we need to make sure that you think about those sorts of things. And that's where you might bring an insurance broker in as well, if there needs to be some kind of coverage in the business to bring in extra income to pay for someone else in your role potentially, if there isn't someone who can step up. Then we get a little bit deeper and we start going, okay, we've dealt with the immediate stuff. Now we have to start getting proactive, think long term, and start thinking about restructuring things that might need to structure, getting longer term plans in place. So maybe have 2 or 3 plans. So you basically de-risk. We don't want all our eggs in one basket. We want to know plans A, B, and C potentially, and how to bring those about. Then start building on your most favorite of those strategies. So what's your best option? Let's start working towards it. What's the time frame? What do you need to achieve from these strategies? So how much do you need to retire on? What sort of figure do you need to achieve from a sale of a business potentially? Or if there was an employee buyout, for example, how long a period would that go over and how much would you need from that? Or if it's going to be a family takeover, how is that going to happen? And what sort of income are you going to continue to get from the continuing business, if anything? So looking at various options and what you need, of course, because you don't want to get to the end and then have to have a forced sale of your business and get very little for it. And then start implementing. So there's your main 5 steps as I see them. And of course, these can be broken down into multiple other little steps, but overall, that's what you'd be working on. And, you know, it wouldn't have to be done very quickly. You'd want your contingency sort of stuff done sort of within a month or 2. And then you might work on a succession plan over a 6 to 12-month period. And then you might review it every 5 years or something like that. So, or implement and say, okay, my time frame is 5 years to have this done. So, immediate contingency issues, planning for an emergency. So, that car accident that has you out, or gives you a permanent head injury. And so, even though you're alive, there's no coming back to the business. Um, Sudden death. Um, And then other immediate issues around that could be buyouts. So if you're in partnership with other people, do you have sufficient insurance for a buyout of a partner? If a partner does die suddenly, how are you going to pay out the family for the other half of the business, or however your business is structured? So then thinking about those things, which I've got another slide for, which I'll cover off shortly. I'm going to dive deeper into each of these contingency issues. So important roles. Who is going to do all this stuff for you? So your executors are the people in the will who make sure things happen from that perspective, that your will gets done. Your executors can't do anything until you pass away. The will doesn't start until then. So if we're thinking about an emergency situation with not death, it's obviously not going to be under the will. Trustees can be in a number of different situations. So a trustee could be someone who becomes a trustee under your will. So they might initially be an executor, and then they might have to operate your business for a period of time and be a trustee in that perspective, because they're operating it on trust until they can sell it. Or they might operate it on trust until someone else can step up, a beneficiary. Or a trustee might be someone in an existing trust structure that then has to step into your role as a trustee, or if you're a director of a trustee, to step into that role as well. So thinking about who can take on these roles for you. I spoke briefly about guardians too. This is about any little people, young kids that you might have in your life. Guardians are really important in your will. Beneficiaries, I think, sometimes are less important, thinking about who's going to get what than who's going to do what needs to be done. If you have a broad understanding of who your beneficiaries are, then you've got a great starting point. However, then if you think about a family business, do you want to tie the next generation together? Is that a great idea? I've seen many 50 and 60-year-old brothers who've been tied together in a business for 20 years, and they're at each other's throats, and it was probably the worst thing that their parents could have done to them. So thinking about how your beneficiaries are going to inherit in some ways as well, like how much you're going to rule from the grave, because it can be done, but we like to give our beneficiaries more flexibility so that they can work it out for themselves. And talking to your family, if they're going to take over your business, to see if that's what they actually want. You might be assuming that that's what they want, but if they are working with you in the business, they might only be happy to do that because you're there. But ultimately, if you retire, they might not want to be there anymore. Or if you're running a business and you assume your kids are going to come back and run it for you, they might think very differently. And then attorneys, I think, potentially even more important than executors, because again, an attorney steps in an emergency situation and keeps things running for you. And if you are, for example, in that car accident and then just can't work for 3 months, but you need to come back to your life, you really need someone who can keep your life running for you. Who are the people that can do that? So you might think about a mixture of people, because you might want your spouse, for example, making your health and personal decisions and not your business partner, but you certainly need your business partner to have specific powers appointed there to be able to run your business financially, to be able to sign things on your behalf. It might be a manager that you need to step up. You can have up to 4 people. You can spread the load around. You can also say that they have to act jointly or by majority, or you can say they can act separately except for decisions up to, say, $20,000, or for the sale of a major asset, then they have to act jointly. So there's all sorts of ways that we can massage and work this and have instructions in it. But powers of attorney, as I said, sort of even more important in a business situation because you're still in the midst of life and you certainly haven't got to the point where you've retired and things are simple. So, talking about powers of attorney, the main types you have general. General might be really useful for you if you are going away. So, if you have to go overseas for a short period of time to I don't know, organize some kind of thing for the business, some conference you might go to for a couple of weeks, or you might be going to source a new supplier or something. A general power of attorney only applies for a specific period of time or a specific task. If you lose capacity, it stops. So it's not a great one for in case of emergency. That's the enduring one that you're thinking of. So an enduring power of attorney is called enduring because it endures past you losing capacity, which is the whole point of it. If you can't do things for yourself, you need someone to do things for you. Health directives can also be quite useful if you have some really strong feelings about certain aspects of your healthcare. You can leave instructions for those. And then I've briefly touched on the instructions for attorneys as well. Spelling mistake. When does a power of attorney begin? So usually we wouldn't begin a power of attorney until you've lost capacity. So it's dormant unless there's a doctor's certificate saying you can't make decisions in this area or she can't make decisions about this or that. So we can have it begin once you've lost capacity, or we can say it begins immediately. But if it begins immediately, you're not giving your own power away. Your attorney then has to act on your instructions and in your best interests, of course, as well. So you can appoint someone to do things on your behalf. And that might, again, be a manager or something like that. Or you might have someone specific for a specific task. Single or multiple people, as I said, you can have up to 4, and then whether you have them have to act jointly by majority or be able to act separately, and the conditions around how they act, and more specific instructions as well. You can appoint an attorney to act as in your role as a director or as a trustee. So important things around keeping a business running as company decisions, being able to deal with banks, being able to deal with mortgages, real estate, those sorts of things can be built in. Now, coming to business partners. So this is one of the things where I see big problems can arise, and I'd prefer things to be done better up front than have to deal with things when they become a problem. So when we go into business with business partners, with mates or someone who is aligned with us at a time, of course it's all rosy and everyone's excited at the time. We go and see an accountant, we set up all the structures. The accountant doesn't usually advise us to get a business partnership agreement or a shareholder agreement or whatever structure you've got, because we're not ever thinking about breaking up or anything going wrong. It's better to put a partnership agreement or a shareholder agreement in place while everything is good, rather than try and fight it out after you no longer get along. Because I've been there and done that multiple times for people, and it's worse than marriage sometimes. So in a partnership agreement or a shareholder agreement, you want to know how to value your business. We don't want to be arguing about that. We want that set already. We want to know what happens if one of you voluntarily exits, and a voluntary exit could be retirement. We want to know what happens in an involuntary exit. So an involuntary exit would be a car accident, a sudden death, or a terminal illness. You want to go and you don't really want to go, but you have to go. So we know how the business is valued, but we also need to know how much you're getting paid out in these situations. And we need to know how the business is paying for it, which then covers insurance coverage as well. So if there is going to be a buyout, a compulsory buyout situation, how does the ongoing partner even afford to buy out the other partner? Like, you don't have hundreds of thousands sitting there just in case. So the business can pay for life insurance potentially for partners in case of an emergency, total and permanent disability insurance. So those sorts of policies can be obtained. Loans and security. So a partnership or shareholder agreement would also work out what sort of loans a partner could take for a business, when a partner could use business assets as security, or putting up personal security for business loans, and how to get out of those as well if you had to exit, because banks don't readily give up security. Conflicts of interest, how to resolve them between yourselves. Who's entitled to copies of bank records, who needs to sign things, and how. When big decisions are being made, how are big decisions being made? And who contributed what to begin with? And is that a loan to the business? Is that something that should be paid back on top of your value of the business? Or is that all you're entitled to back? All these sorts of conversations. So we've dealt with fact-finding, contingency plans, de-risking the business. Now we're starting to plan our various potential plans A, B, C. Who are going to be our successors? Are we relying on a new business partner coming in and then eventually leaving? Are we hoping it's the next generation to take over? Is it going to be employees that step up? Are you going to sell to a competitor? Is there, a bigger competitor in the market that might want what you have? Or are you just going to put it on the market? So there's lots of options. You need to then start thinking about, well, what's my best outcome? Where am I going to get the best bang for my buck, I suppose? Thinking about what you have to retire, or what you're liking to get out of it. Where are you most likely to get a good lump sum, or are you comfortable with a longer term buyout with a trickle of income? Because depending on these situations doesn't always mean that you're going to get a lump sum. And I suppose, as I said, sort of try and have 3 different scenarios and work those through. And then we've already said your accountant's got to be one of the professional team that you pull in to talk to all this stuff about. Talking about whether there are concessions that you can get on capital gains tax. For retirement, there are concessions. So if you were to sell, remember, if you started your business from scratch and now you're selling it for a lot, that is a complete gain, right? So it could be potentially a huge capital gain. But there are retirement concessions. So start talking to your accountant about those. Start working out when you'd be entitled to something like that, what the qualifications are for that. Depending on the structure of your business will also be dependent on your tax issues, because each sort of structure is taxed differently. Some losses and gains can also stay within entities, and others are automatically contributed out to beneficiaries or individuals. So starting to think ahead and thinking of changing structures potentially. If you've got a 5 to 10 year runway on your succession plan, you can still change your structure to be much more tax effective. When you start thinking about moving assets around, though, there's stamp duty to pay. So you do have to be careful of how you're restructuring. And of course, there's all sorts of other costs to be thinking about in in changing structures and in professional fees over time, how much something's going to yeah, cost on a runway. All right. Coming back to some of your contingency planning, there are a few myths, tips, and tricks that I like to tell people about. So if you jointly own assets, so whether this is with a spouse or a business partner, and there's an issue where you might pass away together, the youngest is deemed to have outlived the older person. So even if it's passing at the same time, in the natural course of things, the older person is deemed to have died first. So everything goes in accordance with the wishes of the youngest person in that situation. So if you do have a business partnership, understand that that's jointly owned. And so if one person passes away, it automatically passes to the other partner unless there's some kind of partnership agreement. And so thinking that detail through from the point of view of older or younger is really important as well. The effect of marriage, separation, and divorce on a will, but also on other structures too, is important to think through. So a marriage automatically revokes a previous will. There are exceptions, but that's how it works. A separation does not. So if you still leave everything to your spouse in your will and you've separated but not divorced, that can be an issue. If you divorce in your will, it's treated as if the person you've divorced has passed away. There is such a thing as a 30-day rule after you pass away. So someone has to survive you for 30 days to take a benefit under the law unless you change that time period. The forfeiture rule is another interesting rule. So if someone else causes your death, and it doesn't have to be a criminal penalty, it just has to be negligence. If someone else causes your death, they're automatically disinherited. A gift over to children is another interesting concept. So if you leave things in your will to your children and one of your children dies, but they have children, it does automatically go to your grandchildren, unless you say you don't want it to. But that's the only situation where it applies. It applies down the bloodline. Whereas if you leave something to a brother or a sister or a nephew or a niece and they pass away, it doesn't automatically go down to their kids. It's the opposite. Your residue is everything in your estate that you don't specifically deal with. So we often then say, okay, we'll divide our residue up equally, or we divide the residue up 10%, 10%, 80%, or something like that. We don't like dealing with residue in dollar figures because we don't know what the residue is going to be. And we also want our residue always to add up to 100%. There are quite often wills that forget to give away a part of their estate, which can be very tricky. Then it goes back to the laws of intestacy when someone doesn't have a will. So if you only give away 90% and forget about 10%, the laws of intestacy will cover that 10%. I haven't seen a will that gives away 110% though. Specific and general gifts. So this is an easier concept to think about. A specific gift is fairly obvious. So I give my engagement ring to such and such. I give my motor vehicle to such and such. It's specific. I give my property at this address to someone. It's my thing that I have, that I name and identify and I give away. A general gift is much more interesting and can sometimes catch people who do their own wills because they don't know about these little drafting issues. So a general gift is where we compel the estate to buy something for someone. So I often give a funny example, which will stick in your mind. So my sister would love a red Ferrari, but I don't have one. So I can't leave my red Ferrari to my sister in my will. But what I can do in my will is say I leave a red Ferrari to my sister, and that compels the estate to buy a red Ferrari from my sister. So, I mean, the way this is most often done in a will is I give 100 BHP shares to each of my grandchildren or something like that. So you don't own those, but you could compel the estate to buy something for specific people. But there are ways to use it, which can be interesting. So just bear that in mind. Specific or classes of beneficiaries. So again, a specific beneficiary is easy to think about. I leave my engagement ring to my eldest daughter and name her. So that's specific. A class of beneficiaries is I leave everything equally to my children. So it's the children that you have alive when you pass away, or I leave everything equally to, I leave $10,000 each to my grandchildren. But your kids might not have finished having kids. So it's the grandchildren that are alive when you pass away. And if there are any more grandchildren who were born after you pass away, they miss out. Mutual will contracts are an interesting little thing to think about in terms of making wills with husband and wife. So some, or more and more often actually, husbands and wives are concerned that if they pass away, particularly if they pass away sort of in their prime, that their spouse is going to go on and get married and meet someone else. So a mutual will contract says, okay, we make our wills like this together at the moment, and we agree that we won't change our wills without the consent of the other person. So they change their wills in the future, they do it together, and so on and so forth. And then when one of them passes away, they then can't change their will after that. And the contract also says, and they won't diminish the estate either. So you can't meet someone else and go and give everything away to that other person either. So interesting concept to have. You could also use a similar concept with a business partner. You could make a contract between you as to how things are going to happen, and then agree that nothing will change unless you both agree to that change. So that is essentially the main part of my presentation. I'll again put up some contact details. So they're my contact details, but I've also put up Tony O'Connor's details. He's the litigation partner if you do end up in difficulty. And an indication of prices I thought would be important as well. So quite often, families can often get away with doing the whole package with this second one. A family legacy plan includes wills, powers of attorney, advanced healthcare directives, superannuation binding nominations. But then if you need testamentary trusts, or you have existing family trusts that need altering, you're sort of looking at the family protection plan. Family succession plan is a bigger issue where we're moving real estate and other assets around to make sure that the succession works. Potentially, it's because we need to avoid certain situations happening, but that's sort of the fees that you're looking at, and that's a couple, so that's not each. So there's a bit of an indication for you. And of course, disclaimer at the end, I'm not giving specific information. This is all just part of a general information for your learning, because we do like educated clients that have had quite good thought about what they want to do. And then we can get right into doing some good work and making sure that we avoid problems. So I am going to stop the recording and open up for questions.